Hi everybody, and welcome to our second session in Environmental Law and Policy. We're going to build today on what we established last time, which was that a nuisance exists at common law when someone's conduct causes a substantial, unreasonable interference with someone else's use and enjoyment of property. Let's see how this concept can apply to a classic environmental dispute involving air pollution caused by a copper company that's discovered copper ore in the southeastern United States in the early 20th century, in the early 1900s. I had you read two cases, Madison versus Ducktown Sulphur, which was a case from the Tennessee Supreme Court about this dispute, and Georgia versus Tennessee Copper, which was a case in the United States Supreme Court involving the same type of mining, in this case resulting in the very first U.S. Supreme Court opinion on air pollution, and authored by an incredibly famous jurist, Oliver Wendell Holmes. If you want to know where we are, here's the southeastern United States, and this is the corner of southeastern Tennessee where the copper was discovered. Roughly, this is what the area looks like in a state of nature. It's beautiful, deciduous hardwood forest that characterizes the southeastern Appalachians. At the time copper was discovered, there were people living in this part of the world, and they included small homesteaders, like the plaintiffs in this case. The plaintiffs in this case, of course, are not ecologically innocent. Small homesteading and agriculture can cause great damage to local ecosystems, but roughly this is what their type of enterprise looked like. When copper was discovered under the best technology at the time, the way the copper companies got the copper out was to mine the ore on its own land and then put the ore on huge roast piles like giant bonfires that went all day and night to burn away the surrounding ore to get at the copper underneath. In the course of doing so, huge volumes of sulfuric smoke was released from the ore, and no one doubts the effect that it caused. Here are a couple early pictures taken at the time of these operations. The sulfur-bearing gases would come down like superacid rain on the surrounding forests, just denuding it. And these forests roughly became moonscapes. In fact, there are arguments that you can see the scar left by the mining companies, which was about the size of Central Park in Manhattan, from space, as just a huge denuded area. The court characterizes the harm, understanding that it is in fact real and pervasive, in a fairly understated way. It talks about the croplands being destroyed and people being concerned about their health. There is no question but that these effects were found, and the court finds it to be so. The next question is, given what the copper companies are doing, is it a nuisance? Before we see what the court did, what do you think? Just take our cases from last time, Meadowbrook Swimming Club and Slaird versus Kluers, and ask yourself, do you think that what the copper companies did was different from the surrounding norms and caused a substantial interference with the plaintiffs, the homesteaders' use and enjoyment of their property? If so, do you think it's a nuisance? If you said yes, I would agree with you. But perhaps more importantly, the thing to realize is that in the first of our cases, the Tennessee courts also agreed and held this was a nuisance. Thus, it's easy to see right away it established a precedent in which the general law of nuisance could be applied to air pollution, sort of a classic environmental nuisance. But there were really two things going on in this case. The first sort of easy one was, is this a nuisance? The court says yes. The second one is, what should be the remedy? What do the plaintiffs want? They want an injunction. They want an order from the court to the copper companies to stop this pollution. Now, to be honest, it wasn't clear that there was any obvious technology that hadn't already been tried to stop the pollution. This was the best way known to smelt the ore to get at the copper underneath at the time. So an injunction probably would have amounted to an order to stop business. The alternative would be an award of money damages, in which the copper companies could keep causing the harm, but simply pay the plaintiffs for the harm caused. does the court issue an injunction? The answer is no. And I find it sort of interesting to see the way the court even framed the problem. When looking at it, the court says they could almost not take seriously the idea that an injunction would be ordered. Should we shut down, the court says, the works of a great mining company for relatively small tracts of land worth very little money? To do so, the court says, would practically be a confiscation, that's the court's words, of the defendants, the copper company's property, without paying them anything. Well, no surprise if that's how the court looks at it, that it does not issue an injunction, and instead forces the copper companies to pay damages, the amount of harm done, at least as measured by the court, to the plaintiffs. Obviously, this is not what the plaintiffs wanted, and to that extent, they're not very happy about this result, even though the court found there to be a nuisance. They didn't want money. They wanted their quality of life back, and money is not the same thing. That's not what they wanted. It's not what they sought. But apart from the fact that the plaintiffs didn't get what they wanted, could we sit back for a moment a little more theoretically and ask ourselves, are there any values that can be accomplished by forcing a defendant to pay for the damage that's been caused? This is a good time to bring in a little bit of classic economic theory. In economics, this type of damage, the air pollution in this case, is known as an externality. That means there are effects felt beyond the boundaries of the company or the entity causing the problem. In this case, the damage is felt on property belonging to someone else, and it's a negative externality. It causes bad things. By forcing defendants to pay for these damages felt by others, those sorts of damages suddenly become relevant and visible to the defendants. They have to take account of them. And the idea is, if they cause more harm than it's worth, they'll have to either stop business or have an extra incentive to find a less harmful way to do things. That's called internalizing the externality in the entity that's causing the harm. And in theory, it at least could lead to what economists call efficient results, in which we're sure that there's some net good coming from what defendants do, so that even after they pay off all the harm, it's still worthwhile for them to continue. If we want to think about this more generally, however, we realize that this idea of internalizing the externality and sending the correct market signals to the world that factor in the harm caused by pollution depends on a whole variety of assumptions. In particular, we have to be sure we get the price signal right, or put another way, that the court gets it right. What sort of variables does this involve? Well, for one thing, we have to be sure that everyone who's been injured is at the table, having their harms measured. So in this case, there are plainly some neighbors that have brought suit. But are we really confident that everybody and everything that's been harmed is at the table as a plaintiff? For example, what about people in other neighboring states that might not have sued under Tennessee law? If they're not at the table, the harm caused to them will be invisible in the court's award. As well, what about nature? Not only was the farmland belonging to the plaintiffs denuded, but all of nature was. Is there any way that that cost can be factored into the equation? If we assume, moreover, that all the current interests are accounted for, there's another issue, which is how do we account for future generations? After all, in this case, the harm caused by the copper companies lasted for almost a century. That means there will be generations of people, even after the copper companies were long gone, that felt the effects of this pollution. We have to factor in those costs to be confident that, in fact, what you're doing now is a net good for society. So we have to be sure we understand how to value this on future generations and make sure that's at the table. When we talk about the theory underlying these nuisance cases in our fourth session today, I'll come back and address some of the valuation questions that are raised by this concept of internalizing the externality. But that is, in fact, what the court does in Madison versus Ducktown Sulphur. It awards money damages and says that's the best we can do. Let's look at the other case, Georgia versus Tennessee Copper. This arose out of the exact same processes in southeastern Tennessee by the same type of copper companies, except now it goes to the U.S. Supreme Court because it's a dispute that spans two states. The actions take place in Tennessee, but they're felt in Georgia, a neighboring state. And in this case also, it's not private landowners seeking compensation for a private nuisance. This is the state attorney general, the chief law officer of the state of Georgia, bringing a lawsuit claiming that the pollution is a public nuisance. It goes to the U.S. Supreme Court. And in a very famous case, the court has no trouble finding there to be a nuisance. So in that sense, this is very similar to the Tennessee case, Madison versus Ducktown Sulphur. Both courts agree this is a nuisance. But this time, as to the remedy, the U.S. Supreme Court says, if the state of Georgia really wants an injunction, we really see no alternative but to grant it. And it did. It ordered the chemical companies to reduce their pollution in a way that will not interfere with the forests and the land and the public health of the people of Georgia. As the court said, if a state wants to insist that its forests not be destroyed and its citizens be protected from air pollution and their health is preserved, that is one of the core benefits and prerogatives of a sovereign entity like a state in the United States. And we will enforce it with an injunction. In other words, that's not for sale with mere money damages. Tennessee Copper went on to have a big influence on environmental law. In 1941, in an international dispute between another smelter, this one in Trail, British Columbia, whose fumes were crossing the international border and affecting farmland in Washington state in the United States, the arbitration panel, citing Tennessee Copper, held that the smelter was responsible for the harm caused even across an international border by its fumes, just like Tennessee Copper was responsible for the fumes it caused over a state border in Tennessee Copper. This principle that one state, although having the right to exploit resources within its jurisdiction, owed an obligation not to cause harm outside its borders, was later reaffirmed in a famous United Nations conference in 1972 in Stockholm, Sweden, in Principle 21 of the Stockholm Declaration. Tennessee Copper was cited again in 2007 in a famous case in the U.S. Supreme Court, the first case really establishing the federal government's obligations on greenhouse gases. In that case, the state of Massachusetts had sued the EPA, the Federal Environmental Protection Agency, because at the time, EPA was not taking action on greenhouse gases. Citing Tennessee Copper, the court in Massachusetts versus EPA held that a state has an obligation and a responsibility and even special legal standing to defend the territorial integrity of its own borders and the health of its citizens against out-of-state environmental problems like greenhouse gases. This case in turn went on to impose on EPA an obligation to reconsider greenhouse gases as a type of air pollution, and in that reconsideration was born the EPA's current approach to regulating greenhouse gases in the United States. Next time, we'll step back from Tennessee Copper in this litigation and look at the advantages and disadvantages of using nuisance law and principles like it as a matter of environmental policy. I'll talk to you then.